Good morning, beautiful humans, and welcome to Defense Diaries. I'm your host, Bob Mata, and this is our continuing coverage of the Commonwealth of Massachusetts. Allison was really trying to distract me behind screen here, doing like all the things that she can do in her womanly ways. But we are continuing to cover Karen Read's trial, which obviously is coming to a conclusion. So big day yesterday, shock day in so many different ways yesterday. I'm still stunned that Brennan put on nothing in rebuttal. He put on nothing.
Well, he hasn't officially done it yet, but he will be putting it.
Oh, do you think he's had the night to sleep on it? Maybe
no, I don't think he changed his mind.
Wait, why can't he change his mind?
Because he told the judge, I don't know. I was thinking about that, actually. Did he tell anything that, oh, shit.
So wait, did defense definitely rested?
I heard the man say the defense rests, subject to blah, 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 blah. But then Brennan, when the defense rests, we will be resting.
Wow. All right. I mean, I guess there is, jury's not going to be there today. So he done. Once she excused the jury for the day, he done. So it is, it's a fascinating turn of events because I'm here to tell you that getting the last word is probably the biggest advantage that the state has typically in trials. So, wait, we glitching? Are we glitching out? Ooh, that no good. That no good. All right, so let's see. Are we glitchy? Screen is blooping, but I think it's YouTube. Yeah, it's definitely not us. If other channels are doing it, then it is what it is. Let's see. There is a glitch in the Merricks. I know, but Afton accidentally typed Merricks, which I thought was funnier. Let's see. I mean, we're just going to have to power through, y'all. We're just going to have to power through. Some days, did you guys see the guys? Betterow thinks it was to save Hank's ass. I mean, in what sense? Well, I mean, is that really saving Hank's ass or is that saving his asses? I don't know. But I don't see how that's saving Hank's ass. Like, I think, I don't know. It's hard to say. It's hard to say. I think that it's like I was talking about yesterday, though. You know, Allison hates when I kind of call shit and then pat myself on the back. But I was telling you, it's like calling Welcher in particular was a real, damned if you do, damned if you don't type situation. And it's exactly what happened. I think ultimately Brennan probably felt that he was going to gain less than he would end up losing by putting him on. Because remember, a rebuttal case isn't, I'm going to bring this witness back or bring another witness on just to add to my case in chief. That's not what it is. A rebuttal case is literally where you bring evidence through witnesses in order to directly rebut things that were raised during the defense's case in chief. So the real question that Hank was probably asking himself, in light of the fact that Welcher did no actual testing at all, applied no science at all, is what could he rebut from Rentschler? You know what I mean? So it's like I was sitting there, I don't know what the dude could get up there and rebut. Could he just get up there and say, nah, I disagree? He didn't do any testing. And then as far as Hartnett, she was just that had just been a black hole, because the X-ray thing. Oh no, that was Welcher. But the shirt thing with the cuts is just, it's again, you're not gaining anything, and you're standing a very, very high chance of losing a lot by bringing either one of them up. So the end result for Brennan was that he lost the biggest advantage that prosecutors have, which is to get the last word. Just apply it to your life and any kind of argument that you're in. We all want the last word. We all want the last word. It's hard not to try to always have the last word, So, and it's no different in a case, in a trial. So, it was a huge, huge sacrifice. Are we still glitching? Is it still glitchies? Glitchy, because I can try to. You're glitching here too. Yeah, it's more to rebut. Contradict, rebut, maybe we're parsing terms, but rebuttal is different. I like, it's hard to say what he was going to bring around for. It's hard to say. And frankly, at this point, and who gets, so how bad's it glitching? Hold on. I'm going to try to, I'm going to try to at least, all right, if I vanish for a minute, I'm going to try to refresh here. Or maybe I should wait till Allie gets on. I don't know. I don't know if anybody else backstage what'll happen. Trying to check out these comments here. It's YouTube, but it backs out and pops right back up. Wow. That's weird. That's weird. Hold on, I'm trying to check it out on my phone to see if I can see what's going on, because I can't see from. Hold on, I'm trying to check it out on my phone to see if I can see. Yeah, it hasn't done it for me yet, but oh yeah, there it is. I just saw it. The screen just went black and then it popped back up. Yeah, that's annoying as shit. Are other channels doing that? Yeah, it's a like a black screen for half a second. You think it's StreamYard again? What? Wow. I hope that doesn't do that all day. Well, I don't even think this is going to be all day thing. You know, I mean, the jury instruction conference not going to. Woo! Liz, we made it to the end. Now we wait. Power to Alan for his closing tomorrow. We love him so much. We do too. We do too. And Liz, we're all behind you. We're all behind family, and importantly, we're all behind Karen. Alan's going to knock it out of the park. We know that. We know that. But do me a favor, Liz. Tell him to make sure to look at my tweet today, just to get a like. I knows, but he has to pound the concept, the definition, and the application of reasonable doubt over the jurors' heads, point where they can't stand it anymore. It has to be done. It cannot be short shifted. It has to be done. He has to explain it. He has to, over and over and again. Only give the definition, because reasonable doubt is so hard to define. It just is. You know, they're going to get the instruction. We're going to go through it. Tracy had long ago sent me all the proposed instructions. And it's like, it's one of those things where we are all really, I hope we're all supposed to be caring about jury instructions, because if you didn't learn it in the first one, if you didn't learn how important they are from the first trial, with the whole kerfuffle, with the verdict slip, I can't help you. I mean, Alice and I have been telling y'all, shit's critical. It's literally the instruction booklet that's sent back with the jurors. It's the rule book. So as far as that goes, I mean, I don't know anything more important than that. So yeah, we're gonna be going through that. Hold on, let me try to pull up my mail here. Boo, boo, boo. Okay, I gotta go to Tracy's stuff. I got OnlyFans on. OnlyFans blurry as hell this morning. I'll show you what I mean in a second. Okay. Let's see. Okay. Boop. All right. I like that. I like that. Oh my God. It's doing the Acrobat shit. Okay. Acrobat like updates a lot. Okay. Got that. Okay. All right. So in the here's what I'm going to do. I'm going to pull up OnlyFans just so y'all don't get nervous. I mean, I don't know how nervous you'd be getting over the jury instruction conference, but you should be real if we're missing it. It's my point. That shit blurry. Super blurry. Oh, you know what I forgot to do? That I feel terrible about? Forgot to do this because it's important. Yeah, welcome back. Welcome back. How many heads we got in here? How many of you remember Welcome Back Cotter? The young heads, if you've never seen Welcome Back Cotter, I highly recommend it. Little John Travolta pre-Scientology. Quality Travolta right there. Vinnie Barbarino. Yeah. When Allie gets in here, it's happening everywhere live. It's the plague. Do we think it's Hank Brennan? Is he behind some computer hacking away? Pushing his glasses up? trying to shut down all dreams so we can't talk shit. Ooh, Hank. I have to say, the trial really went fast. You know who it didn't go fast for? Were Karen Reed. It did not go fast for Karen Reed. Like every day in court, like when you're a defendant, like a nightmare. It's like you're living in a nightmare. It's so surreal that you're sitting in that room and it's so every day was torturous for Karen. You know, but she put on a brave face the whole time. She continues to put on a brave face because, you know, internally what's going on with Karen is what goes on with any defendant when your life is hanging in the balance. Utter turmoil. That's what's going on with Karen. And so I'm sure she's relieved that this is coming to a close. Thank you, Liz. Oh, good. Thank you very much for that, Liz. I was actually, Allison was telling me, if you're still here, was telling me to get on a plane and fly out there for verdict watch. I hope, against all hopes, that this isn't a long deliberation. I hope that this is a short deliberation. I hope they give it 5 hours and they come out and find her not guilty.
You are unmuted.
Because that's what should be happening here. It's what should be happening here. It's got the papers. It's got all the papers.
For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Ms. McMahon. Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti from Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed.
Where's
All right,
Alan?
So, Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right.
Interesting.
So, first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for the prior finding not guilty of all the evidence.
So, no, we can do that now. So now that my ruling is on this, evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take the time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence. And in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle. And if he was not hit by a motor vehicle, none of these 3 indictments may stand. Both, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she talked about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very instance where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death, a dog which mysteriously was absent from the home at 6:30 in the morning on January 9th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept, a dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorty Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensics you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorty Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on scientific method,
Thank you.
Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. SUV that day, before it was towed to the Canton Police Sallyport, the taillight was merely cracked. When he was shown photos of what it looked like in the Sallyport after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Albert who is on video, hot, angry. I meant Higgins, yes. Yeah, the same Brian Higgins, who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an tight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all 3 indictments.
Oh, they got Lally going up there. Wow. Hank is just
Thank you, Your Honor. Commonwealth
thrown in the
requests that the
towel.
defendant's motion for required finding not guilty at this juncture, as it was close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples when it came to Officer Barros. His testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that Ring camera video. Essentially, the Commonwealth would submit that the defense witnesses conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. La Posada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
So, Mr. Yannetti, you know I have to view this in the light most favorable.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied. Okay?
Made the record. Made the
All
record.
right.
what
So
matters.
regarding the
Preserve the
charge-
issue.
So we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw 2 of our requested instructions, which shorten things today. I think it's,
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction. You're withdrawing that?
with regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else for proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
Hey, oh, Allison. Hey, oh, Allison.
Hey, babe.
Hey, hon.
They're not using
Oh,
microphones
that's
this
right, you
morning?
filed, I saw it in email. I don't have a hard copy of it.
Sorry.
She saw it.
Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're gonna go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right? All right, so model homicide instructions, just as last time, so that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand, the court's commission might be on this, but as far as the instruction related to murder charge.
Fuck, this sucks.
Yeah.
All right, so we will deal with that. I'm going to go through the defendant's instructions, are sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the
Verdict
each
sheet.
individual indictment. I'll give some further language on that. You've got an instruction and proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it. So I will make it crystal clear. Okay. So I'll give you that, Ms. Giannetti. This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction? Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfactorily the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor.
We don't like
When
it.
it comes to the Bowden, and I would incorporate, and I know there's no request for instruction, third-party culprit, but the Commonwealth would be making similar requests that counsel be prohibited from making a third-party culprit or Bowden.
Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from questions from the defense, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that have put evidence or anything of the like. So in the instruction and arguments are based or predicated in the case law evidence. And obviously, as the court is well aware, there's a specific instruction that no matter how powerful questions to counsel are not evidence.
It is boosted, right, babe?
Yeah.
If the court looks at what is actually in evidence.
Wait, let me double check that, Ashley.
There is no basis whatsoever for not only
Oh,
Bowden
Lord.
and third-party culprit.
Wow.
Is it better?
But
Well,
specifically
it boosted.
counsel to make that argument, of course, both. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what is the Bowden evidence that warrants an instruction?
Well, you didn't let us bring most of it in.
Your Honor, the police not secure the crime scene properly. They use inadequate materials, active evidence. Chain of custody was contaminated and corrupted. There was evidence of the bias, the investigator failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the extent that everybody
Pause, babe.
else was not an open-ended investigation. They wanted to focus on one person and one person only.
So the Bowden defense, for those of you that don't know, is, I mean, the instruction deals with the inadequacies of the investigation, that you've heard evidence about inadequacy inadequate in the investigation. Lally kind of circled that into third-party suspect evidence, and it sounds like the judge is saying, well, I think Bowden's fine. I'm, but she's not allow a third-party witness, maybe a third-party suspect, maybe instructions. So she's asked Yannetti to argue what the evidence is and what most of us, what we're saying and what most of you in the chat is saying. And the judge is like, where's Bowden evidence? Well, Your Honor, you wouldn't let us call a Bowden expert. So yeah, when Lally's arguing, well, the only way they got in this evidence was through like their questions to witnesses, and they didn't put any real evidence in on it. Well, the judge didn't allow them to, but they did get into evidence that witnesses weren't questioned alone, that there was a horrible chain of evidence, that all the things and that
As you keep hearing Canoni say that she feels that she had a more robust instruction as to presumption of innocence, and she also said that she feels that her instruction as to Bowden was more robust than the defense's proposed instruction. And
wait, everybody's saying the stream is frozen.
It's all over YouTube. It's there's nothing we can do about it. Is
So
it frozen, or is it just doing that blackout thing? I don't think it's frozen. All right, but let me read this.
okay.
So this is how it reads. Oh, here. Do you want me? I'm gonna try to refresh StreamYard real quick now that you're on.
Okay, but everyone's saying it's fine, but go ahead.
Is it fine or is it
Or
not?
just go ahead. It froze for a sec. It's back, but let's just.
Yeah, let me do it one time. All right, I'm gonna reload it.
Well, hello. I hate to see myself solo in the big screen this early in the morning. Come back, babe. Come back. Yeah, so the judge, I did think that there are some of the Massachusetts instructions that are very robust. So,
All right, I'm back. Get to share this little puppy. Okay. See if that lets us get rid of the glitch. We'll find out. All right, so let me read this real quick before we get back to Yannetti's argument. This is their proposed instruction. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the tests or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omission tends to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. So that's how theirs reads.
well, that's pretty good. She thinks hers is more robust.
That's what she said.
I got to find my cheaters to read the instructions on this prednisone to see if it says take with food. Oh, wait.
All right, I'm going to blip back a couple here.
Take with food. All right, I'll be right back.
Okay.
You reset. Make sure it's blue. Oh, it is. Okay.
Day one, it was focused on one person and one person only. And just responding briefly to Mr. Lally's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about in an investigation. So to say that we didn't introduce that evidence when we tried to do it, when we were
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction.
There you
So
go.
third-party culprit's an entirely different animal here. I know. But tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, that you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay?
Yeah, I understand. That's crystal clear.
Okay.
And that's really what I was seeking, this clarification. based on
Yeah. So Mr. Yannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
Just while we're on page 8, I just wanted to, Commonwealth does have an objection to the DG instruction that's at the top of page 8.
Yeah, I have a check mark next to that. Mr. Yannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest DG Batista argument that we would have, does not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on your own cell phone. It could have been done. It wasn't done. We have to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounded with her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr.
And
Lally?
I would also add, Your Honor,
Sure.
they did seize her vehicle at around the same time. So, that it goes to, I think, the issue of custody and my client being able to deny it.
All right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the trooper spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, over the course of that. They spoke to her while she was seated on the couch in her parents' living room. The parents were present, no one was restricted from eating. And it did not end in any sort of custodial situation. She was taken into custody, she wasn't arrested. Yes, they did seize her cell phone and her vehicle based on information that they had developed throughout the course of the day and from statements from Ms. Reed herself. But I don't think that transforms that conversation or interview in her parents' living room into a custodial interrogation. The bigger issue that I have is placement, as far as there's already been within the same requested jury instructions or requested remaining practice, an then following the DAG and Batista language in the defendant's request for jury instructions, there goes on to all of this other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of the practice. I don't think it's something that should be highlighted in two different sections. I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and have this testimony from the stand, that initially she said she wanted to be fine with answering questions, but they wanted to get into many details. And then when the questions became centered on, or more centered on details, at that point, and I know that's not evidence to the jury, but of course, well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview. And I don't think that it rises to the level of the case. So I would ask basically that everything on the
You can hear the woman talking.
All right. I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that does not apply to the interview at your residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the,
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We asked the court to repeat that one sentence.
Okay. So I did not see this when I took a quick look at the view. All right. I'm not going to repeat it. All right. Lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
I might just reference that.
Sure.
Only language in there that I would object to.
Okay.
Testimony of a police officer or someone else who works for a law.
All right, I want to pause and discuss a couple of things. I feel much more comfortable doing that during a jury instruction conference than I do during trial. So, babe, you were gone for the discussion regarding she is going to give the Bowden instruction. She is going to allow third-party culprit as to Bowden, meaning that she's going to allow them to get into the fact that there was specific evidence that police had available to them regarding Brian Higgins, and they failed to investigate that aspect. She's not, let me just tell you what her ruling was. If she's not going to allow them to full blown get into any kind of third culprit.
Right. So because I heard from your computer while I was down there that she said, but not to, you can't say he had motive.
I mean, I don't know. She's not going to bar them from being able to argue the fact that that the flirting was going on. You know what I mean? Like how far she's going to let Alan go on that. Like, and I don't know how much you need to spell that out. You know what I'm saying? In terms of, you know, this guy clearly had his eyes set on and designs on getting with Karen, and that didn't happen. And that the text was late that night. You know, I mean, the text really, his last text, like literally preceded them leaving the bar. So I don't know how much they need to get into motive above and beyond that. I think the thing speaks for itself. The other thing that people are asking about, so that was a win. I never thought that she was going to deny giving the Bowden instruction. This investigation was way too fucked up. So what a lot of people I've seen asking in the chat, they waived their absent witness instruction.
Right. I see EJ said, why do you think the defense withdrew the missing witness request? Or he says motion, but why wouldn't they at least request it for Proctor?
And this is how I want to handle it. I'm going to read you what their proposed instruction was, and then I want to get your thoughts on it. So their absent witness instruction was this. In this case, you have heard some reference to a potential witness who did not testify. If the Commonwealth did not call a potential witness to testify and 4 conditions are met, you may infer that the witness's testimony would not be favorable to the Commonwealth. The 4 conditions are: first, that the Commonwealth's case against the defendant is sufficiently weak that it would normally be expected to call that witness to testify. Second, that the absent witness would be expected to offer important testimony that would support the Commonwealth's case. Third, that the absent witness is available to testify for the Commonwealth. And fourth, that the witness's absence is not explained by any of the other circumstances in the case. If any of these 4 conditions has not been met, then you may not draw any inference from the witness's absence. If all 4 of the conditions have been met, you may infer that the witness's testimony would not be favorable to the Commonwealth if that is a reasonable conclusion in the circumstance of this case. This rule is based on common sense. First, you may not draw such an inference unless the Commonwealth's case was sufficiently weak that it would be expected to bring in the absent witness. Second, you may not draw such an inference unless the absent witness's testimony would be relevant to the defendant's guilt or innocence in some significant way. Normally, the Commonwealth would have no reason to bring in a witness who would only testify about minor details or who would only repeat what has already been said by other witnesses. Third, you may not draw such an inference unless there is evidence that the Commonwealth was able to bring the absent witness into court. And fourth, you may not draw such an inference if the evidence suggests another reasonable explanation for the witness's absence.
So I think, they knew all the things that they know now that they knew when they put that instruction up. But I think they might have decided it's better for them to just argue it to the jury without that instruction, which makes it like you've got to have this, this, and that.
Right.
Just ask yourselves, why didn't the prosecution call Proctor? Why didn't they present them to you?
Why wasn't the lead investigator in this case called to the stand? Ask yourselves that question over and over and over and over again. I agree. I think that 3 out of the 4 are clear. I think that one of them is arguable. Yeah.
I think with Proctor, there's another reason why they wouldn't call him, and that's everything that they've already heard.
Yeah. And I mean,
he's fired. He did a shit job. He's biased. He's,
Yeah. I mean, why the Commonwealth didn't call him for sure, and don't confuse it. Like I want to be certain that people aren't misunderstanding that instruction. That is to the Commonwealth. That is not to the defense, because I think people can't be like, I think people are like, oh, Proctor's on the run. The defense wasn't able to subpoena him. They couldn't wrangle him. So that's why they didn't call him. That's why they want that instruction read. It's not what that instruction's for. That instruction applies to the Commonwealth, not calling the lead investigator in the case.
Right.
Not
doesn't have to call anyone. So there would never be a missing instruction
right
against the defense.
Right.
Oh, what do you mean by that?
Rewind it a little bit.
Okay.
I might just reference that.
Sure.
Language in there that I would object to.
Okay.
That's why the police officer or someone else works for a law enforcement agency.
Oh, what do you mean by that?
think that was taking into account the dispatcher, perhaps. We're not.
Yeah, I'll do police officer because the police testimony, I'm not going to go beyond that.
I think that might be
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics. What page you on? Okay.
One suggestion there was indicates Commonwealth introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think that Francis introduced more graphic.
Yeah, so I would just say you've seen photographs. Or there were photographs in evidence. I instructed twice anyway, maybe 3 times on it. So I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally. So let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Gianetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Gianetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I
Pause
will
it real
give
quick.
some. I'll give the redacted exhibits instruction. Witness preparation.
All right, so the judge is just reading kind of like the title or the type of instruction. So, for example, you heard one there that said, what is not evidence? I'm going to give the what is not evidence instruction. So that's going to be what the lawyers ask, and no one asks the questions. If I struck something, if I this, the lawyer's questions aren't evidence. The opening isn't evidence. The closing isn't evidence. So that's what she's talking about there. So they're kind of just glossing over the ones that are like, these are types of instructions always given kind of thing.
Let me see. Let me see. I'm trying to position this so you guys can see the captions. I saw Megan's comment here. Let me see if I throw something up. All right, that's good. That doesn't block the captions. All right, you good for me to start it?
Well, and pay attention to our questions. So we're going along and kind of answering
Preparation
them.
for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate though, where it says during trial.
Right, not during trial.
During the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth request for that instruction.
All right.
They're joining for it to say during trial because they said that they told him that.
Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any testimony that came in.
I thought it came in through Kaylee.
No.
I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction.
What?
She testified.
That is not a prior bad act.
Okay. All right. So did I give it any other time that there's another event that I should highlight? I don't think so.
I guess it did come in.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right. Those were the limiting instructions I wanted to get to. So
We would object to the prior bad acts being linked to the Higgins text message.
all right. I'm going to take a look at that, Mr.
We
Leslie.
would object to
All right.
prior bad acts. Did she just call Mr.
Consciousness
Alexis?
of guilt.
You're on call.
Okay. All right. All right. So tell me where the difference is in what I gave last year
This is painful. You can't hear
from
what
the model
weird-
homicide instruction on second degree murder and where you're saying I should not this year, Mr. Lally.
Right, so the only,
1 second. Let me just pull that up.
Hank just wants no part of jury instructions. He's like, go ahead, Lally. you
Okay.
handle it." It's
your uncalled request is merely not for any change or alteration in the instructions that were given other than there are three prongs of malice. And essentially, the Commonwealth is requesting is that the jury be instructed
Speak up.
merely on third prong malice, because that's the only one that really applies to these factors.
Okay.
The Commonwealth here, the first two prongs are essentially strangers in this situation, and you don't need to see next one. Avoid confusion.
Do you have supportive case law for me to single this out? What do you say, Mr. Yannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm, not intent to kill him. It was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
this is painful to listen to.
I could say the parties agree that the
You mean in
first
terms of
prong and
the
second
how
prong
shitty it
are
sounds?
not applicable here?
Nothing we can do about it. I mean, do you guys like it better if I turn the extra booster off?
Well, I'm not going to say you agree if there's no agreement.
That's-
Rewind a little bit because I can't. They're saying stuff.
say you-
That's,
I think we're just at the position where we'll refer to the court on this.
Well, I'm not going to say you agree if there's no agreement.
so I can't even tell what they're talking
You can
about.
get me a case by this afternoon.
I will endeavor to do so, Your Honor. We will. I don't have it.
Oh, the
Case-
I'm
captions,
inclined to go with the model.
the captions are on, y'all.
I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason. I understand, and I don't.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe.
What?
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin.
That's the stupidest thing I ever heard.
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the model.
If I alter it, it means I remove those two. That's all.
Right, no, we just want.
Yeah, sure. My guess is that won't happen. But
All right, babe, we need to
can
go
see.
back and figure out the fuck they're talking about.
all right,
How far do you need me to go
I'll
back?
do that. But
I don't know.
they know what I'll find third and find you probably afternoon.
A little more. Okay, let's no
Here,
more.
like, we got to go
more.
back further than that.
The Commonwealth view, the first two prongs are essentially strangers in this situation, and you don't see next one.
Okay, so he says, pause it a second. The Commonwealth suggests that the first two prongs are extraneous and they're only going to confuse the jury. And I think they're talking about the intentional homicide instruction. We might have to go back a couple seconds more to see if that's what they're talking about.
Okay, let me go back. Let me see what she's saying here.
Because then there was this whole consciousness of guilt thing
All
that
right.
was sort of.
I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So,
We would object to the outside accident link to the beginning's text message.
all right, I'm going to take a look at that, Mr. Leslie.
We would object to the
all right,
prior bad acts being linked to.
consciousness of guilt.
Okay.
Okay. All right.
Wait, I think they withdrew it. Loop back,
All right.
babe.
Okay.
Back.
Right there.
All right, I'm going to take a look at that, Mr. Leslie. All right. Consciousness of guilt. Okay.
Commonwealth
All
is
right.
withdrawing it.
All right. So tell me where the difference is in what I gave last year
These are better.
from the model homicide instruction on second degree murder.
They are.
and
All right.
where you're saying I should not this year, Mr. Lally.
Okay, so pause it.
The only,
1 second. Let me.
So it's the model homicide instruction on second degree murder. That is what they're talking about. That is what the rest of that conversation was all about. Consciousness of guilt is withdrawn, which means the jury won't get an instruction that says you have been shown consciousness of guilt evidence, and you can consider that evidence, as consciousness of guilt, which I mean, it's just strange.
Wasn't that their whole fucking point of showing
Right.
those fucking ridiculous videos?
That's what I was going to say. It was Hank's entire argument early on. And I know we were screaming when it was happening. That is none of what you just said is actually consciousness of guilt. That's ridiculous. And then there was that whole thing. Alan Jackson was like, if he wants to play it like that, that's not consciousness of guilt, but we've got no objection for whichever one that first one was.
Right.
So there will be no consciousness of guilt instruction. they are asking for the first two prongs of the second degree murder to be removed. And the judge is saying, like, I understand why you guys want it removed. I just don't know if there's anything that allows me to remove it because these are standard jury instructions. So that's why she was proposing, well, how about I just tell them you're going to hear stuff that has no relevance here because I have to read everything. And that's just ridiculous. Like, the judge has the ability to give outside of the standard jury instructions, but one of the sides is supposed to propose something that does say this is an acceptable alternative, you know, instruction.
No, and I just want to be clear. No, the clips are in evidence. All right. So the video clips are in, that they are part of the evidence. What they're doing is, and it's an interesting concept. I'm trying to kind of wrap my head around why they would be withdrawing it. So Hank obviously can show the clips again, and I'm sure he will during closings. But what they're not going to do is they're not going to give a jury instruction about consciousness of guilt. And that was really Hank's biggest thing with the clips, is that all of these statements were consciousness of guilt, that they reflect consciousness of guilt from Karen Reed talking about how she hit him and, you know, all the other things. So I think that maybe the Commonwealth didn't want the instruction because it kind of reeks of desperation. I mean, to me, their entire case is those clips.
All right, babe, they're saying that, like, people have fixed this issue.
Wait, are we still glitching?
Yeah, I guess Tracy sent us something, a text. She's like, it's bad. Wait, that's at 9:01. Never mind. I don't
Yeah,
know.
come on, man.
Sorry.
Come
All right, I gotta
on.
go pick up Scout's friend. I'll be listening from the car.
All right. Well, the car needs to be cleaned out. The car has to be cleaned out.
Okay.
But let me handle that. No, you stay. Put your ears on. You stay. Put your headphones on. No, it's not an argument, Spoogs. I don't want you to injure your arm anymore. I'm going to move the boxes down to the basement.
Oh, you're sweet.
But I'll do that real quick. And then
So
you want to.
You just want to pick up Amelia, or you want me to?
I'll do it. I'll do it.
I mean, I don't care either way.
Well, I got to get. You handle this. I'm going to handle that.
Okay. I got to pull up the screen. So give me a second.
All right. I love you.
Love you. He's so sweet. Okay, YouTube, Boston 10. What? All right, hold on. I'm going to try to get right where we were. All right. Okay. All right, let's see if this is about where we're. So I was looping back to the end. So we had went backwards to see what were they talking about these two parts of the instruction they want removed. So I should have gotten us right back to there.
I thought it came in through Kaylee.
Oh,
I should say it did come in through Kaylee.
That's not after.
That's when I gave the prior bad acts instruction. She testified. Okay.
They went through it.
Mr. Brennan
essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm. She's not intended to kill him.
But that's
and
part
it's
of
just
the-
third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not.
Whether it's permissible
I don't have strong feelings about it.
to take those two parts of the
I
instruction
could
out.
say the parties agree that the first prong and the second prong are not applicable here.
I don't think they should agree to it.
I think we're just at a position where we'll defer to the court.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have it.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but
Right, so
I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason for this. I understand, and I don't certainly want to
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe.
I wouldn't mind.
We wouldn't have an objection to that.
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs.
all right, let me hold on one sec. Let me pull up the proposed instructions and tell you what the two prongs are. I think this is it. All right. So of course my computer's not cooperating. Oh, I think I think this is it right here actually. If I could just scroll up. It looks like A is that she intended to kill John O'Keefe, but then there's an or intended to cause grievous bodily harm to John O'Keefe, or, and this is the one they're going, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. So they are ors. So the murder in the second degree says, in order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, the defendant, A, intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. And then I have a footnote. Commonwealth requests the jury be instructed only on the third prong. So that's what they're discussing now. And they're talking about, well, what Yannetti said is like, I'm struggling like you are, Your Honor, to determine whether or not that's permissible to only give the third. And a lot of times jury instructions will say, like in the notes of the jury instruction, that it can be, you know, you can delete if not applicable type of thing, and this doesn't. So that is the three prongs that they were talking about. Let's go.
I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see.
All right, then he has
Move those.
to see
Since
it
that won't happen.
before.
All right.
he does it.
So, lesser included offenses. Did you want an OUI instruction? You were.
We're asking for that.
Okay. All right. His motion. Right, I think that's it, aside from Mr. Alessi's motion
go.
regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on the redaction subject to the court's ruling.
Okay,
But it wasn't in final form. We believe it's in final form now.
and you all agree that it's in final form?
Well, they haven't seen it.
Oh,
But I'm going to
okay.
give it to them now. Can I hand this to the court?
Sure, thank you. All right, so
The only other issue, Your Honor, is we do have a.
hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it. So,
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence from
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't.
We have to redact it, so. these are
Okay.
redacted. It's not a problem, but.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Blally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then, will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for competition, Your Honor, if I didn't.
You did not.
Okay, we do have one.
Yeah, a proposed verdict slip. Probably
Okay.
not guilty.
Sure. Is it the same as last year's, but now with a?
It's different.
Okay. All right.
You'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually in
Yannetti, jeez, I'm sorry.
She's done that multiple times.
So, Your Honor, you'll recall, we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
The analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say,
The
of
less
the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least like three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports it, the defense requests it, that the court must give it. Having said that, the verdict slip that was used in this matter last year, the Commonwealth submitted is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently, while this case was going on, tried before Judge Law, in which he had similar issues. I believe used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in action. I don't have a copy of it on me, but I can certainly get the court a copy of it. But that may be somewhat helpful with the court's opinion.
Okay, was that on murder case?
It was not, but it had to do with a felony motor vehicle homicide.
Yeah, I'll take a look at it.
Mr. Turk.
Mr. Turk. Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we
Wow.
appreciate that. Judge Wells is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're.
Okay.
they
And
need.
that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right. So Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering. Okay.
Do you need an extra copy, please?
Sure.
This is the
Yes.
All right. So the state, as the
Or you know
defense-
what? Just mark it for identification, Margaret. We'll do that. Chrissy, please.
what?
Just for ID.
No, they want it on the record. They want it in the record.
LL for ID.
No, they want it as a part of the record in case this goes to appeal. Why is no one saying anything?
Thank you. Mr. Lally.
Your Honor, just one request, circling back to the constitutional instructions. So
I guess-
withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference in this argument to the jury related to specific areas which we would need judicial approval before we did. So the two areas that are sort of listed within that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from one metal that came to her parents' residence indictment, and then certain statements made in reference from the various clips of the later statements.
Okay.
In particular, would be the one where essentially she says it's a
Jesus, Hank, speak up. I mean, Lally.
All right. Mr. Yannetti, do you want to weigh in on that?
Yes, quickly, objections to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house.
Wow.
The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being
No.
any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other criticisms.
Yes, so I did want to ask you though, Mr. Yannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No,
Okay. Okay, I just wanted to give you the opportunity. Okay.
All right. So what she just said there. So here's what just happened. So Lally stands up, and I know we can't hear him. He says something like, oh, wait, we do have consciousness of guilt evidence. We are going to argue consciousness of guilt. This was the same thing that, right. Kasha's like, he withdrew it for fuck's sake. So it was this ridiculous argument. Like, I don't even know how she's saying it is a reasonable inference from the evidence that Karen Reed left the O'Keefe's house and took her car, went to her parents' house, and somehow that is consciousness of guilt. It is so absurd. So what the judge is saying, I'm allowing them to argue it. So in the same sense that Bob and I were like, well, you know, she's not letting, they withdrew their missing witness instruction, but that doesn't mean that they can't say to the jury, well, I mean, you guys have to ask yourselves, why didn't you hear from this witness? And why didn't you hear from that witness? That's the same thing. She's saying she's going to allow the Commonwealth to argue that those, and I think she shouldn't allow it. And I thought she shouldn't allow it from the jump when this got in. And I thought the defense should object to it, which they just did at this point in time to prevent them from making the argument at closing. But she's telling the defense, I'm going to allow the prosecution to argue that that conduct of her moving the car that day, blah, 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 is consciousness of guilt. And that's something a guilty person does, as ridiculous as it is. So she's like, based on that, are you sure you don't want the consciousness of guilt instruction in because there is some language that is beneficial to the defendant? Now, let me see if I can, I still have it open. So let me see if I can find it right now. Well, it's going to take a second because I got to have this scan. So we'll just keep going, and somebody remind me when we get to the end of Alessi's. So the other thing that's about to happen is Alessi is going to, God damn it, my computer's freezing up. But it's not going to affect us. I just have this box in front of my face. But that Alessi's going to argue that they need a stronger curative instruction for the whole fiasco with the back of the sweatshirt and the holes in the sweatshirt. I think he should be asking for some kind of curative instruction when it comes to the x-rays, to be perfectly honest. That was a fucking scam. That was some serious misrepresentation to the jury. That right there should have been a hands down, kicking and screaming motion for a mistrial again. Like, even though they've now sort of, the defense was able to rectify it. It's just so ridiculous that Brennan was allowed to do it. Oh, how did you get down here, Nook? All right. Let's let this go.
All right. Anything else? Anything else, Mr. Yannetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redactions.
that's great. Thank you. One less thing you all have to do today, okay?
This is Mr. Alessi.
I know. All right, so let's make that, are we switching that new redacted version with an exhibit number? Do we know what it was before? Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
Right, this is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just. 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealths.
This is a clean copy.
So that will now be 209 in evidence. You know what? Can we make that 209A? We need, Ms. Giannetti, we need to keep record of the first one that was not redacted. So any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
What do you think? Yeah. Yeah, so we'll switch it back to ID and this will just be 209. All right, did we have an ID number on it originally? Can it still be that?
Is it redacted, the NNN? Or is it, no, it can say that.
Okay.
Right? 'Cause this is the-
Oh, it's just NNN. It's not,
Well, where did it?
no, it became 209.
Or I'm just going to blue past this.
Yeah.
The redacted version will now just.
209.
Yes.
Yep.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Alessi, I'll hear you.
All right. So, and just to circle back to like the Wolf PowerPoint and the Rentschler PowerPoint. So yesterday, Brennan said, well, I didn't object to the Wolf PowerPoint for strategic reasons. Like I didn't mind about that one getting in kind of thing. Like, or there's something he wants to argue from it. There's something he likes in it. But he did object to the Rentschler. So the judge is like, well, defense, you didn't object to Welcher's PowerPoint. So that's why that's getting in. The Commonwealth didn't object to the Welcher. The Wolf PowerPoint. So that's getting in. But there was an objection to Rentschler. So I think she's not letting any of it in is where she ended with that. And you know, the reports of the experts don't usually get into evidence. They're used to present their testimony and to talk about, but the reports themselves don't usually get in. So, you know, Hank didn't like Rentschler's, that's for damn sure. But there was something about Welcher's he was willing to let slide. So let go in because he wants it for some reason. All right, Alessi, you're up, buddy. Bump. Dun, 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 dun.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of, that's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally can state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
But Your Honor, the Commonwealth's position is ultimately I defer to the court as far as whether or not it's appropriate instruction to give in final charge. What the Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the court's final charge.
All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why did we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting too, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened.
So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe it's what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Wholly
Didn't I
insufficient.
include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't.
This is not an official transcript, right?
Exactly, Your Honor. So I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so,
Might have given that, but that's not important.
Your Honor,
I mean,
I
that's not
believe
he's
what
focusing on
is
now.
fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury therefore should not weigh and value his opinion. This is very, very significant. And I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error. It's undisputed about the error. To me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there. Again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally, keep your voice up, please.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with a witness on the stand, things can happen. Mistakes can be made. It was recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever.
Yeah, Hank, what do you have to say for yourself, asshole?
Misstatement was made at the time as far as whether it's from the testimony from the witness or the question from counsel was immediately remedied, was taken care of. I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi.
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them
5
start
or
deliberating.
5:30. It's like, just let them go till they're done.
We have judges. During the last trial, during the deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that. But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right.
Hmm.
Does the
Security
Commonwealth
issues.
have any objection to that schedule?
No, Your Honor, not at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning.
Sure.
We'll counsel here at 8:30. All right, thank you.
All rise for the court, please.
I gotta go.
Yes.
Goodbye.
I was trying to see if we got a hot mic moment there. All right, they shut it down. They shut it down. All right, so I think we could do, I was hoping Bob would be back. That maybe we could do some of the opening if you guys want to do that. Hank Onset NKB says word on the street is Aperture bailed on Hank. Yeah, well, I'm sure that didn't happen. Not after $400,000. I'll tell you that much. Hey, welcome to fam, Tony. Weird that Burgess, so unsolved Christeries. Weird that Burgess seemed more like a real engineer than Welcher. I mean, that's possible, right? Shannon L says, remember to smash your ham sandwich on that like. Wow, nice one. Meg was telling us about all the lives. Rebecca writes, says, do you guys believe Hank thinks he won the cross with Dr. R or does not know between the hoodie debacle and his Aperture expert lying about x-rays, they will be fried on cross? No, I think he knows. There's no way he thinks he won, and that's why he's decided not to call personally. I think he knows he's fucked. Jessica, thank you for your super sticker. Twigs, member for a month. Nice. Positive vibes for AJ, the defense team, and Karen. Yes. Just Jim says, if the man on the street shows up, that's Bob, I will call out of work to go there. Here's towards a plane ticket. We talked about this one, the missing witness instruction. Thanks, Unsolved Christeries. And thanks for being a member for 11 months. So Mickey asks, can they still include Albert not coming out and Albert rehoming the dog? So again, I think that they can point those things out, and they just have to walk a fine line between saying, and that proves somehow that they've got motive to kill, and that proves they killed them. They can hint at it, but not say it. But you can still be like, you got to ask yourselves, why wouldn't the Alberts come out? What the hell happened to their dog? I don't even know if we got evidence. Did we ever get evidence in that they rehomed the dog? Does anyone know? Because I don't know that even came in this time. Maybe it did. There's too much for me to keep track of. LS gifted 5 memberships. Thank you. Just Jim, I would just pull up the Commonwealth motion on jury instruction 3 prongs. Okay, we did that. The Commonwealth wants to remove the intent and whatever the second prong is. Yep, we went over that. Thanks, Jim. Milo says, anyone catch Bev using Proctor's phrase, whole different animal? talking about Bowden. Bad choice of word for that topic, right? Milo's mom. Can we watch AJ's opening after this and see what he left unanswered? I think we might be able to do that. Hoping Bob will be back here, but Milo says, was she supposed to walk in a blizzard to her parents? Now he's talking about the whole consciousness of guilt with the car thing. I honestly, I cannot figure out how he thinks that's consciousness of guilt and how the judge thinks that's a reasonable inference. There's nothing reasonable about that inference. There's absolutely, positively nothing reasonable to say that that has anything to do with consciousness of guilt. Let's find out where Babe is. And then Dr. Russell's audible gasp. So how far are you, Babe? Well, hold on a sec. All right, he says throw the AJ's opening on. That's a great idea. So are Jackson and Little missing to put together the closing argument? I think that's probably what they're doing. Is working on that for sure. It's just, you didn't need them all there for that. Like you didn't even need Hank there. Hank didn't need to show his face. He just sat there not doing anything. But yeah, I think that's probably. Let's see what the rest of you are saying over here in the chat. Oh, so Polly says rehoming Chloe came in through Jen McCabe. She repeated the rehomed, not got rid of quote. All right. And can we watch Turtle Boy? Like, is that on somewhere? Is anyone streaming it? Maybe we should be doing that. It's me, Melanie. Is somebody streaming that? Is there a way for me to get that? I mean, we have that Zoom that Bob invaded and talked on. I don't think that's appropriate to, or if it's available. Turtle Boy's on Zoom. The Young Jerks did. All right, so should I play it? All right, let's see if I can figure out if I can remember how to get to it now. Let's see. It's going to take me a minute. I got to find where I had this thing. All right, hold on. Stand by. Talk amongst yourselves. I'm going to figure this Or I'm kind of afraid to join with my full name like that. Can anyone tell if young jerks have themselves in there as young jerks? Like, can you see their names on the? Maybe I should go pop over and see what it looks like because I have it up. I'm ready to hit join, but I'm afraid to do it. Fuck it. I guess I'll just join. Here we go. I don't think this is how they're getting in. I'm afraid. I feel like canceling. All right, I'm getting out of here real quick. I'm gonna go see what it looks like on the young jerks. I don't want to be like where Bob, he's like talking into the thing. See what it looks like. Sorry for that yawn in your ears like that. This can't be right. No. It's like a different young jerks. What? Oh. What's this?
This is how I got access to Wegovy for up to 60% off retail price. Weight loss by
Got my ads. Oh yeah. All right, maybe I just try to join. It looks like they have theirs. All right, let me just try. It looks like they're watching it through Zoom. All right, I'll try it again. I'm putting in Defense Diaries name. Bob says Better Rose coming on tonight at 8. All right, so I turned off, but I don't know if I'll be able to talk during this. So I was like, do not connect my audio. Audio. Like, no audio. I don't think it's, I don't know. I'm not getting in right away, though. Should I just stream theirs? All right. That'll make it easier. I'll be allowed to talk. All right, Young Jerks says I can stream theirs. Thanks, Trace. But I'm not gonna be able to rewind. Wait, technically I guess I would. So what should we do, people? What should we do? Should we start at the beginning? Should we just pick up wherever they are? Kaylee said Yuri also gave more info that Chloe was rehomed and the new name. Okay, so Milo says, I don't think anything could beat her gasp until we got to the ew. Yeah, right. That was Dr. Lapisada with him being like, the brain's like tofu, right? Yeah. Jen says, thank you, Alibab Mods. Things have been difficult for me lately, and getting here with DD has helped more than you can imagine. Oh, that's so sweet. I'm glad to hear that. All right, guys, that's what we're going to do. We're going to put on Young Jerks. Let me pull that. Let me pull it up. Then at least there's no chance that we accidentally start speaking into the Zoom somehow. See, some reason I keep getting to the wrong Young Jerks stream. That's 3 months ago. All right, hold on. Here we go. Now I'm at the right one. All right. So boost it. Share it. All right. So here is the question. I mean, should I just rewind it? Start at the beginning? Yeah. I mean, I guess we kind of have to. Up here, about 30 minutes.
And do you swear in the matter now hearing to tell the truth, the whole truth, and nothing but the truth, so help you God?
Thank you very much. Good morning, sir.
Morning.
You're Colin McCabe,
What
That is correct.
the hell?
and you are related to some of the witnesses in the Karen Reed matter.
Yes, I am.
And who are those folks?
My brother Matthew McCabe and my sister-in-law Jen.
So back on 2/26/24, you were here as part of a group of people going to court in the Karen Reed case, right?
That is correct.
And it was a 2 o'clock hearing.
I don't know what that means.
So you were there in the afternoon, weren't you?
Yes, I was.
All right. And so you know that the court goes till 1, there's a lunch break from 1 to 2, and then they start up again at 2, right?
Yeah, I have no idea what happened.
Okay. So do you know what time you were here with this group that day?
With the group, I know I was there in the afternoon. I don't know the time.
Okay. How did you come to be informed that you should meet at that location?
I spoke to my brother and I said, I'll meet you down at the courthouse.
And that's Matt McCabe?
That is correct.
Okay. What was your understanding of what you were going to be there for and what's going to happen that day?
I was coming in to support the O'Keefe family and the witnesses in the case. So, support group.
Have you ever met Lindsay? Had you ever met Lindsay Gattani before that day?
No, I had not.
Okay. And when you got there, did you have any conversation with her?
No, I had not.
How many people approximately had gathered at that area behind the registry of deeds in your group?
It was a good sized group. It was kind of broken up into multiple groups, but maybe 20, 30 people maybe. I have no idea.
And was Paul O'Keefe there?
I have no idea. He might have been. I have no idea.
So did someone introduce you to Ms. Gattani?
No, I've never met her.
And you said it broke down into 2 groups as everyone came towards the courthouse, is that right?
That is correct.
Who was in your group?
In my group, multiple people, I have no idea who they were. My sister, my aunt, my cousin.
What are the names, please?
My cousin?
Yeah, the names of the people that were in this group.
I don't know everybody that was in the group, but Kathy Faulkner, my aunt. Shannon Sullivan is my cousin. Megan McCabe is my sister. I think a few of my sister-in-law's sisters were there. I don't know their last names off the top, man, but Michelle and Denise and everybody else. I don't know who else was there.
What was your understanding of the hearing that was going to happen that day?
My understanding was it was a quick hearing that day, go in, see what happens, and then leave.
Okay. So you walked towards the courthouse from the registry of deeds, correct?
That is correct.
And which way did you walk? Let's say you're walking towards the courthouse from the registry of deeds. Did you go to the right around the building, or did you go to the left around the building?
Came up the driveway side, so I think that's the left around building. If you come from behind, or if you're looking at it, to the right. So it depends on what side you're on.
Okay,
So
so,
rear, it's on the left side. You're looking at the front of the building.
so can we say it this way, that you came up between this building and the registry?
Yes,
And that's when you came into the court?
that is correct.
What happened when you got inside the court?
When I got inside the court, and then went through the metal detector and everything, came in the building, walked up the set of stairs to where there was a group of people waiting to get into the court.
Did you see Ms. Catani inside the courthouse at all?
No, I did not. She wasn't in.
Did you end up getting into
No.
the,
I don't think so.
Court.
Boris.
No, there were too many people, and there was a head count on the numbers that can get in, so
Crystal.
I was at the back of the line, so I did not get it.
to your knowledge, did Mr. Carney get into the courtroom?
Yes. Well, please.
At some point, so just to set this right, you're outside the courtroom, but in the courthouse.
That is correct.
What did you do while you were in the courthouse waiting around?
Just sat there waiting.
How long did it take?
Wasn't long, maybe half hour.
And what happened after half an hour?
Then after that, when the court let out, everybody started coming down the stairs. I waited for the group that I was with to come out, and then I proceeded to fall behind them and exited the courthouse.
And did you see Ms. Catani as far as exiting the courthouse at all?
At that time, I had no idea who she was, so, but she was in the group of people that was exiting the house.
So I'm glad you brought that up. A lot of these observations that you have, that you've offered, are from you looking at video and then realizing stuff later, right?
Me looking at a video and realizing, yes,
And one of them is figuring out who Ms. Catani is, right?
well, no, when we were in the back parking lot, I then found out who she was when we were back.
So did you recognize her in the courthouse or not?
Yeah, I saw her when she went into the courthouse.
Did she have a piece of paper in her hand?
Yes, she did.
And what was your understanding of why she had a piece of paper in her hand?
My understanding of what that was all taking place when I was standing at the doorway waiting to get in. She had said to the court officer that she had an order against Mr. Carney.
Did you talk to Jennifer McCabe about Ms. Catani at all?
No, I did not.
It's true that Ms. McCabe was with Ms. Catani on the way in and on the way out, wasn't she?
She was part of the group. Yes.
Did you hear them talking?
No, I did not hear them talking.
Did you hear them approaching the courtroom?
No, they were in a different group than me.
So back to leaving. You leave the courthouse, and is it still two groups or is it one big group now?
When I left the courthouse, it was one big group.
So Ms. Catani's in that group?
Yes, she was.
Ms. McCabe, Jennifer McCabe's in that group?
Yes, she was.
And you're in that group?
Yes, I was.
And how many people roughly in the group?
I don't know, probably about 25 people maybe.
And when you were leaving, the hearing had concluded and a lot of people were streaming out of the courthouse, weren't they?
Yes,
Some people went to the right down the handicap ramp. Some people went down straight, right?
that is correct.
There was probably over 100 people out in front of the courthouse when you left, right?
There was probably more than that, sir.
More than that, okay. And you and your group went out of the courthouse and you went down the handicap ramp, right?
That is correct.
And you came to the bottom of the handicap ramp and you were jawboning with some of the protesters out there, weren't you?
Yes, some things were being said to me, and I responded to the things that were being said.
Sure. And you called somebody retarded and you said something about somebody could be committed or something. You're waiting for them to be committed, right?
Yes, might not have been the best choice of words at that time, and I regret saying that, but yes.
And as you're leaving, Ms. Catani's in your group and everyone's sort of walking together away from the courthouse, right? Correct, to go across the street to where the path to park. Right. So everyone's walking at first along High Street towards Dedham Center, right?
That's the name of the street. I don't know the name of the street, but.
Well, let's do it this way. In the street in front of the courthouse.
Yes.
You exit, you get to the bottom of the handicap ramp, you make a right, you're walking towards town.
Yes.
And you're kind of walking towards this building.
What is
Yes.
happening
but
right
across
now?
the street.
Correct.
Then you get to the crosswalk, you walk over to the same side of the streets that this building's on, right?
Yes.
And then you walk down that little street that's in between this building and the Registry of Deeds building, right?
Yes.
So all this time, you're walking away from the courthouse
Walking away from, yes.
and you're walking away from the Registry of Deeds building, I should say the front of the Registry of Deeds building.
Well, no, technically when we're crossing the street, I'm walking towards the registry. And then as we're walking down the side street, then yes, I'm not walking away from the registry of deeds until I get kind of.
Okay, so you get to the side of it, you're walking along the building, away from the front of the building, right?
That is correct.
I'm going to show you some photos. May I approach, Your Honor? I'm going to show you these three photographs. I've shown these to counsel. Take a look at those. Tell me when you're trying to familiarize yourself with those. Okay, are those close-ups of you and your group leaving the courthouse?
Yes.
Are they fair and accurate representations of your and your group's departure from the courthouse that day?
Well, this one here, yes. These ones right here, I don't know exactly where he's at.
Well, do they show the same people that you were with that day?
There was multiple people there. It shows a few of the same people that I was with that day. I don't know if it's everybody.
And so it's, can we agree that it's a partial representation of some of the people in the group when you left?
Yes.
And also these judges in the next group did it.
No objection.
Thank you. Okay.
Exhibit 41, 42, and 43.
Okay. You just take those back.
Sure.
Thank you.
There you go.
Thank you. Show you, we did 41. Who's the gentleman in the red desk?
I'm thinking that's me.
You're hard to miss,
And that's
buddy.
a picture of your
I don't know
group
who
department, right?
You
That's
are.
correct. All right.
That's Colin Albert, right, guys?
And then exhibit 42, who do you recognize in the photo? That photo.
I recognize my sister-in-law.
Names, please.
That is Jen McCabe. Recognize, I don't know her name, but that appears to be my sister-in-law's cousin. And I
Colin
recognize,
McCabe.
one of my sister-in-law's
Oh.
sisters. Not sure which one it is, either Denise or Michelle. Terrible one, you know.
That's
Know which one they are. And I think, it might be a side group of maybe my sister, but I can't 100%.
Thank you. This is exhibit 42 for the record. Thank you, Madam Clerk.
Thank you.
That is exhibit 43. And do you recognize in that photo?
See that this be Chris Albert. One of my sister-in-law's sisters, either Denise or Michelle, and then that's one of my sister-in-law's brother-in-laws. That's Bob.
That's Bob.
And then I see. Looks like my sister-in-law's cousin. I'm not sure her name.
Oh boy, the whole
I
family's gonna hate
see
you after this.
the side of one of my sister-in-law's sisters, which is Denise and Michelle. And
then that appears to be Lindsay Giovanni and.
There were 43.
Thank you.
Is there a jury? What's happening here?
So when you walked out, there was a pretty raucous crowd yelling and screaming. You're engaging with them. They're giving it to you, right?
Yeah, it was a pretty chaotic situation. Yes.
And you never heard anyone yelling liar, liar, did you?
I don't know what I heard. I
know
know
what I
a
heard.
couple things being stated myself, and those are the things that's fine.
Sure.
Bench trial. All right.
Now, in all the video you looked at, all the photos you dealt with, there's no photo, there's no representation of Mr. Carney and Ms. Gattani in the same frame or the same video. Isn't that correct?
From the photos you just sent me, no.
From everything you looked at, you said that you looked at some things to figure out what happened, right?
Well, yes, in one of the, in the video that I took.
So it's a yes or no question. I'm not asking you for a narrative. I'm asking you if in all those reviews, you saw any frames, pictures, stills of Mr. Carney and Ms. Gattani in the same picture or still,
So not a video, just a still of it.
any of it.
Well, in the video.
A still of a video or a photograph, there's no picture
Photo.
where they're both in it.
No.
I don't know about
So
that.
were you aware that day that Ms. Gattani had a restraining order against Mr. Carney?
I heard about that after the fact.
So at the time you didn't know?
No, I had no idea.
Did you speak to Paul O'Keefe that day at all?
No, I did not.
May I have one moment, please, Your Honor? Thank you. Nothing further, sir. Thank you. Thank you, Your Honor.
No redirect, may the witness be excused if he wishes to leave. All
Thank
right, thank you very much. All right, Commonwealth.
Council of scheduling. I'm just going to address the motion of quash.
Thank you, Your Honor.
Council, thank you for your patience. Where are we on this right now? Have you folks talked at all? You remember the court's partial ruling is that the motion of quash is denied as relates to testimony.
Yes, he's our third or fourth witness, I think, Your Honor. And we would like to get a look at his text messages with these other people about this notion of inviting Ms. Gattani with her restraining order to this court session.
What's the witness's position relative to that on motion for?
Let me say, if I may, Your Honor, because I've sat here for a couple of days, so I think I understand the case a little bit better than I did before it started. This is still a Rule 17 subpoena. So relevance is still relevant. At the beginning, I said to you, Your Honor, and I can see that you with. I agree at that time, or I heard what is coming today. If I understand the facts correctly, the operative time frame is leaving the property. I accept that there was testimony that came in yesterday that there may have been some communication with my client about arriving at the courthouse that day. But the question for this case is what happens when leaving the courthouse or back to the registry of deeds and whether there's a violation of an ordinance. I looked at every one of those photos, every one of those videos. My client is nowhere to be found. He was not there. He was no longer a precipient witness to those facts.
What's your position on Mr. Brado seeking some of these phone records that you're opposing?
I oppose it vehemently. I mean, he's asked for unlimited scope on
We're
4 different people.
going to talk about that.
We did talk, Judge, and I narrowed the request to 30 days prior. And
what's your offer of proof of what you believe is going to be relevant from that?
sure. So we contend, Judge, that there's a conspiracy between Ms. Gattani, Mr. O'Keefe, Ms. Jennifer McCabe, and probably other members of the Albert McCabe family to, now that Mr. Carney's out of jail, a couple days out of jail, they know that she has a restraining order. They invite her to the courthouse to kick Mr. Carney out of there and sort of exact some revenge on Mr. Carney, interfere with his reporting, etc. So what do we have for that?
We have,
Let's assume that's the case.
okay,
Where does that go relative to this judge? Let's
Right.
Just,
He still has to leave.
my role as a judge only here,
sure.
not a fact.
Well, it goes to
Let's
it
assume
goes to credibility, Your Honor, in terms of that they're trying to create
Yeah,
a restraining order violation.
bad motive.
Yep, bad
Now, where do
motive.
we go from there? Relative to this charge?
Yeah.
Bad motive.
So Ms. Gitani testified that she was invited by Mr. O'Keefe or the O'Keefe family. She involved another nemesis of Mr. Carney, Kate Peter, that she was the broker of this thing. And, you know, Paul O'Keefe is sitting in the courtroom. He's on video and it's in evidence, walking in with Ms. Gitani. And I think he's a relevant witness to what transpired and why it
He's
transpired.
gonna be in this courtroom testifying.
Right,
But as far as the prelude to that,
right. Well, it's a conspiracy, so they had to have communicated. And, you know, we want the communications of how this was set up to try to create a situation that Mr. Carney would fall into the trap.
I appreciate your offer. I'm gonna deny the text message, Rule 17, but you are gonna be able to call him as a witness. I don't know what the timing is across the street. I want to be obviously sensitive to it, but we have to move on, so we'll keep that in mind. The motion to quash is denied as it relates to him as a testimonial witness. It's allowed as it relates to documents.
Your Honor, Vice President.
So what
Thank
just
you.
happened there
All right.
was Aiden's lawyers are trying to get the phone records of, and I forget which witness at this point, you guys might know even more than me, to show that there's a conspiracy between the McAlberts and the witness, this one of the people who has a restraining order to keep Aiden Carney away or to trick him into a violation. The judge said, you're not getting his phone records, but this witness can be called. So he's not quashing the subpoena for the person, but he's quashing the subpoena as to the documents. They're not allowing Aiden's lawyers to get access to the phone records to show, you know, this conspiracy between them to intentionally get, you know, try to get Aiden into a violation of the restraining order or to have to leave the courtroom, whatever the case may be.
Rest of them.
Yeah, the motion required finding not guilty, Your Honor. Yeah, oh, thank you, Your Honor, I appreciate that. So Judge, even in the light most favorable to the Commonwealth in this case, Judge, there's no evidence of any criminal intent. There's no evidence whatsoever that Mr. Carney was trying to violate any court order. Mr. Carney did everything right. He was at his place of work. And again, no different than if he's at the Exxon station down the street in the mechanic station. He's working. She knew he was going to be there. She goes there to evict him. He goes with it. He gets up and leaves. And he walks a circuitous route down, away, and he checks in with the government. This is the key point here, Judge. This is what's fatal to the government's case. He checks in with a policeman. He reveals the situation. The policeman says, go over there for now. He goes over there. Then things change. The hearing ends early. She comes down. Hundreds of people come down, over 100 people, however you want to see it. You have the video, you've seen it. People come out. Everyone's got a black coat on. Everyone's got black glasses on, black hair. It's a sea of people. Mr. Carney's there. He's live streaming. He's talking about what just happened to him. And he's in the general vicinity of where the policeman told him to go. I would suggest that as a matter of law, the government is a stop from then prosecuting him for doing what they told him to do. And, you know, the only reason we're here is because of the poisonous atmosphere that surrounds these cases with respect to the Norfolk County DA's office and my client and the Reed matter. Any reasonable prosecutorial agency judge would look at the case and say, wait a minute, they're saying there was a violation 10 minutes ago. A cop was there 10 minutes later and they don't report it. And it's just a ridiculous scenario that if they had seen him, in other words, if there was contact, they would have made sure he got arrested. And this is all reverse engineered. They looked at the video later on. They saw that he was there, and then they called, hey, he was there. We just looked at the video. And they're trying to create contact after the fact, Your Honor. Mr. Carney is not doing anything outside of what he was told to do.
No, he did not knowingly violate it.
He went right to a policeman. He was told to go somewhere, and he went there. He was waiting there, Judge. The evidence will show, if we have to do a defense case, the evidence will show that he was waiting there to report to the officer who was busy at the time. He didn't want to go off alone because he didn't know where she was going to go. That's his state of mind with respect to Gitani, is that he doesn't know what she's capable of. He doesn't know what she's going to do next. He just got out of jail from her locking him up for 60 days. So he wants to stay with the policeman. He stayed where the government told him. He wanted to get a chance to report
and document and get the officer to take some notes and write a report about what had just happened. He didn't want to go off this direction or that direction to a car or whatever because he didn't want to end up like Frank Keegan. He didn't want to end up at her mercy. She goes to him. She calls the cops. He had just seen that video of the evidence would show if we had to do a defense case. He had just seen that video a few days earlier, and he sees what she's capable of. He's terrified of this woman. He doesn't want to engage with her. He doesn't want to provoke her. He doesn't want to give her any ammo whatsoever. That's what the evidence showed here in the Commonwealth's case, is that he did everything right. He followed the Commonwealth's representative at the time's directions, and that should end the case, Your Honor. So that, as a matter of law, I respectfully submit, should require the court to enter a required finding based on the government's actions, based on the unequivocal, uncontested testimony surrounding Officer Crump, that he said, go over there for now, and he did that. I would ask you to dismiss the case, Judge.
Mr. Bridle has just treated Your Honor to a lot of pseudo testimony about the defendant's state of mind and has focused on his defense. He said very little about the Commonwealth's evidence. But if Your Honor is instructing the jury, I believe if you follow the model jury instructions, you would instruct the jury that there are 4 things that the Commonwealth has to prove beyond a reasonable doubt. 1, that a court issued a protective order. That's not even in dispute, I think. 2nd, that the order is in effect on the date the violation occurred. That's not in dispute either. 3rd, that the defendant knew the order was in effect. I think we know that, if nothing else, from Mr. Bradle's conversation with the police officer, that he knew the order was in effect. And finally, that the defendant violated the order by failing to stay 100 yards away. I'll talk about that if necessary, but in the meantime, as to Mr. Carney's state of mind, the law is that violation of a no contact order requires no showing of mens rea other than knowledge of the order itself. That's Commonwealth versus Tomasi, 435 Mass at 312, Your Honor. There was no requirement of a showing on the Commonwealth's part of intent on the part of the defendant to violate the order. That's Commonwealth versus Delaney, 425 Mass at 596 to 597. There was no proof that the defendant intended an act that resulted in the violation. That's Commonwealth versus Bowden, 427 Mass at 388. All the Commonwealth has to show is that there was an order that said he had to stay 100 yards away. And if he knew where she was or had an idea where she was, he didn't stay 100 yards. I said in my opening statement, Your Honor, that the defendant did the right thing when he saw Ms. Gattani enter the courtroom. He got up and he left. And if he had kept on going, he would have been fine. He should have kept on going until he got 100 yards away. We can argue about whether or not going down the stairs constitutes the yardage or whether it's a straight line or whatever. But the fact is, whichever way you calculate it, when Ms. Gattani walks out of that courtroom in full view of the defendant, he's about 35 yards away. And he remains 35 yards away. And by the way, he's not staying where the police officer told him to stay. The police officer pointed over towards the street, according to his own testimony, and thought that Mr. Carney was headed in that direction, and then his attention was drawn to the traffic. There's no testimony that he ever came back to consult with the police officer further or that he was afraid to leave. Rather, all the evidence, including the photos, shows Mr. Carney following along Ms. Gattani as she proceeds down the street and getting even closer to him by the end of that journey. So he's well within 100 yards. I introduced some photographs of Ms. Gattani, Your Honor, that Mr. Carney posted the next day on the blog. I think there are about 26 of them. I don't know why somebody who's terrified of Ms. Gattani would provoke her by filing all those photographs the very next day on his blog. Apparently he managed to overcome his terror somehow. But in any case, I recall Mr. Bradle objecting that he didn't object to the photographs as long as there was no implication that Mr. Carney took them himself. Well, I don't know whether he took them himself, Your Honor, but I do know that in every single photograph we introduce from those videos of Mr. Carney, he's standing there opposite Ms. Gattani holding up his cell phone camera. So he's well within 35 yards. I would suggest that not only has the Commonwealth proved its case beyond the directed verdict standard, it's proved its case well beyond reasonable doubt.
Just one, if I could just have one brief response. Nice job in the case law, but you have to know the person's there. There's knowledge. You can't just be such strict liability. If a person, if the government can prove they're within 100 yards of each other, that's not it. There has to be contact. There's no contact there. The government can't prove contact, and the government is, speculating about where they were relative to each other. They have no evidence whatsoever before you that where they were relative to each other and when. There's no evidence of it, and even in the light most favorable Commonwealth, they've not made it to that threshold that a rational jury would go in that direction. So I ask you to dismiss. Thank you.
Appreciate the motion. The motion is denied. Are you putting a defense on?
Yes, Meredith O'Neill, please.
It's called Meredith O'Neill.
Meredith O'Neill? Meredith O'Neill?
Would you raise your right hand? Do you swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth to help you God? Thank you.
May I inquire your honor? Good afternoon. Good name, spell your last name. And where do you live, ma'am, just generally? What do you do for a living?
Yeah.
And who do you work for? And what's your educational background?
And it's been French, and then the master's in accounting and MBA from North University.
How long have you been an accountant?
Both 12 years.
And do you know Aiden Carney? How do you know Mr. Carney? And how long have you been dating? How long have you known him?
Years.
You know that he's charged here today with violating a restraining order, right?
Yeah.
And you were with him that day, weren't you? Tell us how that came about, that you and he were together and coming here on coming to Dedham on 2/26/2012.
We're looking at the hearing case. We both have obviously been following the trial for quite some time, so we decided to attend the hearing together.
And just for the record, so the factual background is clear, Mr. Carney is probably the most prolific commentator and journalist investigating on the Karen Reed case. Is that a fair statement?
Overruled.
You let that go leading.
And you actually do too, right? You
Yes.
comment on Twitter or X about it here and there, right? And you assist him with that endeavor as well?
Yeah, sometimes.
Sure. So on that date, there was an afternoon hearing on the Reed matter, right? And at the time, Mr. Carney had just gotten out of jail a couple days earlier, right?
Yes.
And that was from a case that was out of this court, right? You know a little bit about it, right? And that you know that the charge in that case was among the charges in that case was a charge of assault and battery, right?
Your Honor, this is Mr. Brady's witness.
I'm just trying to move it along for some preliminary matters, Your Honor.
It's leading, but it's all anecdotal. We don't know most of this anyway. Let's go.
So on the day of 2/26, how do you and Mr. Carney come together?
So work together with our friend Brad Goldstein.
And what was the plan that day among you guys to watch this hearing?
So, so we got there.
Where did you park when you got it?
I parked there.
And did Aiden have a car?
So the restraining order applies anywhere that the person shows up, which would even be in a courthouse. If it was Aiden's case, for example, she came in now, obviously Aiden wouldn't have to leave. But other than that, she shows up, he's got to go. Now, you heard some of the argument, and that was for directed finding. That was at the end of the state's case in chief, with the defense asking, all right, they haven't proved their case. And the government argued that you don't have to show mens rea, meaning any sort of intent or knowingly, intentionally violated it. You just have to show that they know it. But then he added at the end that they had to have some knowledge that the person's in the area. He didn't have knowledge that she was in that area. I guess that's the argument. When a sea of people comes out, should he have known that it was likely she was amongst that sea of people and then left? I guess we'll see what the judge says. And then Crystal said, Allie, break this down. We're confused. I'm confused too, but that's what we've got so far, was that the defense was arguing that the judge should find that the prosecution failed to make its case. All they showed is that Aiden left when he was supposed to leave. And then this sea of people comes out. He's got no idea she's amongst those sea of people. He's afraid to go anywhere. And then her follow him somehow and come to him, and then again claim that he violated it. So he stayed in that general area. So now let's hear what this witness has to say.
In some other location as well?
Yes, about 5 or 10 minutes down the road, he in park, so, I met him coming from his house and then together.
Then you drove to get it closer.
Correct, to the registry.
And where did you park your car?
In the registry park.
So in like the back of the building, behind the building?
Yeah.
Did he leave some items in the car when you guys departed the car?
Yes, his computer and his car key.
So what was your path, the three of you, what was your path to the Norfolk Superior Court?
Into the courthouse, we walked around, I believe this building, between this building and the registry, across the street, and crosswalk, we brought up around 1:30.
Was there anything unusual that occurred in the walk, or was it just the typical assemblage of people outside?
Not at all very typical. Orders carrying and being outside.
And did you have some conversation with them, or did you see Mr. Carney having any conversation with them?
Yes, many conversations.
Do you know who Lindsay Gattani is? And did you see her outside anywhere during your arrival into the courthouse?
No.
What happened when you got into the courthouse?
Well, about 1:30, we weren't letting people in this yet, so we went to security and then went upstairs and waited in a line before they started letting people in about 10 minutes before.
Did you and Aiden and Mr. Goldstein, did the three of you get into the court hearing?
Yes, we did.
And where did you go when you got in there?
That is the third, towards the outside, so.
And if you were looking up at the bench, at the judge's bench, were you on the left or the right?
We are on the left.
All right, so kind of near the windows on the left. Did you sit in the same row as Mr. Carney or a different row?
Same row.
What time did you sit down roughly, if you remember?
But one would have been 1:50 sort of before we lost our time.
Did you have any knowledge of the hearing that was about to commence and what kind of hearing it was?
Yes, it was a motion hearing. There were several motions to be heard, including a vote.
So was this the type of a hearing that you anticipated would be 5 or 10 minutes, or a longer type of a hearing? So you were sitting down. Did the hearing commence at about 2:01 in the afternoon? And right around the time that it commenced, did you see Ms. Gattani? And where did you first see her? All right. And just to summarize, you've seen video of this and you're aware that there's video and evidence about this very snapshot of time, right? Okay. And you remember it though, right? All right. So we're going to just go with your testimony. So when you turned around and you saw Ms. Gattani, what did you see? Set the scene for us.
Right away, identity, and right now I'm being not engaged in it's other family members. So we had identified her and was her name that she's going to be here weekly now.
Did you notice whether she had anything in her hands? Did you make any eye contact with her or communicate with her in any way?
No, as soon as I saw her from the bar, I said, "No, no."
When you turned around to see Ms. Gattani, you were looking kind of towards the back of the room?
Yeah.
You kind of had to turn over your shoulder. What about Mr. Carney? Did you see him, whether he was looking with you or whether he was looking straight ahead?
It was not her. I was just looking to see who was coming in, just wanting to see if it was the judge gave it to other witnesses that he.
Just listen to the question you're asking, just answer that question, then just wait for the next one.
So when you, right at this snapshot of time, when you're looking back at Ms. Gattani, you see Mr. Carney. Did Mr. Carney react in any verbal way, to your knowledge, when he saw or you saw Ms. Gattani?
No, corrected her.
Did he get up?
He did get up and said, "That."
Was he facing the direction of Ms. Gattani when he said that, or was he facing the direction of some other people in the road?
Stay forward.
And what happened next? Right next.
Got out.
He left.
Also standing in there between us, the crowd standing between us, and we left, walked out the door, and downstairs.
Did anyone have to tell you or Mr. Carney what to do?
No, I told him to leave the left, I'm speaking it for him.
What was the time period that went by from the time Gattani walked in the room till you and Aiden had walked out of the room? Where did you see Ms. Gattani go when she came into the room, if you saw?
I did, like, yeah.
I can't hear a fucking
Did you see,
thing.
do you know who Paul O'Keefe is? Did you see Mr. O'Keefe in there? If you remember.
Don't believe me, looking at videos after the fact, and I can't say that at that time, when I was walking out, I saw any of them because I was just focused on getting out.
Sure. In the 10 minutes or so that you were waiting there, can you recall looking around the courtroom and seeing who was around?
I think some of you have been there before, but that's certainly not Mr. Tanya or Devin Davies who walked out after they.
So you leave with Mr. Carney out the door of the courtroom.
Correct.
Where do you go?
we head downstairs, security area where we came in, and a couple people stopped us and talked.
Just gonna listen to the question or not?
So you walk outside and you're
The
going to
judge
the
is like,
courtroom.
listen to the question.
As you guys leave, did anybody from the Alberts or McCabe's or O'Keefe's make any comments about you or Aiden having to leave?
Objection, relevance, overruled.
What did Chris Albert say?
That at the ITPH talk that we did.
Because I have half of mine attorney.
Where did you go? Just physically, where did you go when you left the courtroom?
Right downstairs.
Did you speak with anybody as you were leaving?
One woman, did.
Okay. What was Mr. Carney's kind of demeanor when he was leaving?
Objection to the characterization and to what you want.
Oh, the anxiety stays, the rest does.
Question. When you say he was in a state of anxiety, can you give us some things that you observed about him that made you conclude he was in a state of anxiety?
He told me he was worried and called him out.
So you get down the stairs to the first floor, and what happens on the first floor?
A woman approached us and gave some information about entering the courthouse before.
Do you know that lady by any chance?
Yes.
Who?
Was that in the vicinity of the metal detectors, or where was that on the first floor just generally? Did you stay with Aiden for that, or did you go ahead of him, or were you still together, or what? You exited the court, the front doors of the courthouse? And what was the scene that you first saw when you went outside?
There was it's a smaller crowd of people outside, smaller homes, and a lot of people thought to be hearings, but for these young people, were also police officers.
Approximately how long after 2 o'clock were you guys standing outside?
Probably within 206.
All right, so you trying to dip? Is that what you're trying to do?
Well, the sound is shit, and like we're in the middle of the case. The defense just started its case in chief.
Is she the witness? They have him stand
Yes,
there. This is like some fucking old timey, like 1800s. You stand in the middle of the room in a box type shit.
I know, it's crazy. Crazy.
All right, so
someone just made that comment here. Was
did you announce tonight?
I kind of did, like when I read your text, but I didn't make it like a big announcement.
Okay. The only thing I'm trying to, I don't know where Mandy is.
Yeah, it was Starter Villain. They have the weirdest situated courtrooms I've ever seen.
Yeah, I mean that's some old timey shit. Like back in the old days, like the witness stand used to be like in the middle of the room, and like the witnesses would like go sit in the middle of the room in a box. Yeah, it's weird. So all right, yeah, Bettero's coming on tonight at 7 Central, 8. We'll be talking about all of it. All of it. It'll be interesting. And there's a lot to talk about.
So we're officially going to abandon.
I mean, like we could. Here's the deal.
So.
We could let this. You guys could either go over to Mike.
Yeah, let him just go to Mike.
Yeah.
Because it sounds like shit. I don't know the stuff that happened from the day before. It's definitely a witch hunt. It's ridiculous. We all got the gist of it anyway. That the O'Keefe family and the McAlberts tried to set him up by having this woman Lindsay show up at the courthouse so that he either got a violation.
Is this that trial, or is
that's
this?
Yeah, that's this trial, which is less exciting than the main.
This
trial.
isn't the oh. I thought this was the important trial.
No, this is a violation of a restraining order.
Yeah, this Gaetani thing's a bunch of bullshit. Okay. All right. Yeah, I'm less inclined to want you to have to sit through that.
So Bob's about to take our daughter to Great America and is trying to force me to stay home because he knows I want to get. I know, but he knows I want to go on rides, and he's saying I cannot go on rides with my shoulder. And I'm like, oh, you know what? My shoulder feels a little better today, and if I'm just sitting there and I'm not moving my shoulder, is that going to hurt my shoulder? I mean, like,
yes, it's going to hurt your shoulder. It's like, you know, they tell people with back issues not to get on a roller coaster for a reason, because you get jostled around. I mean, believe me, I want you. Like, I don't have a
I know
ride
you want your
partner.
partner in crime.
Yes,
I
I
know.
do. Like, come with, but I'm just not going to let you go on anymore. It was bad enough that I didn't insist that you not do that backflip. I was pretty adamant about it.
You were.
But you
I
just
thought you were
ignored me
ridiculous.
per usual.
That's not the soul. You're making people think that's the soul. That exacerbated. But it was already bad before that.
I don't believe you. It was
It was.
nowhere near this. It was nowhere near this. This is
Well,
unbearable. It's
well-
been unbearable for you. Like, and you've got a very high pain tolerance. So like I know if you're consistently like Allie's like, oh, like in bed all night. That's no exaggeration. Oh, I'm like, oh my God. It's so it's in a lot of pain. It's in a lot of pain. So I mean, bring it, come, but like you just got to be smart about what you're getting on, you know? Like maybe Raging Bull because it's so smooth, it's smooth like butter.
I don't know. We'll talk about it.
So I don't know. All right, well, like we're getting ready to dip. All right, so here's the deal though. To kill some time, I'm gonna have to use I can't get Mandy, so I don't. Tracy, do you know how to do anything in Canva? Like I just need to switch the date on that better. Oh,
I think Cam might.
let me see. All right, let me ask Cam. All right, I'll be right back.
Let's see if people are saying, "Oh, water rides. Are you guys going to the water park?" Wait. Oh,
It's
Are
I mean, it's connected. What are you talking
I know,
about?
but are you going to the water park? I mean, I'm not going there by myself.
I didn't know if the girls. I don't know if the girls could do it. I don't know. Like I don't know if Scott like Amelia didn't look like she was dressed for. No, they have Great America and then Hurricane Harbor is attached to it, so you can just walk between the parks. Like because we have the season membership, so you can just bounce back between them. But they used to have it way more convenient, where you could literally get to it from inside the park, and then for what God forsaken reason they cut that down, and now you have to leave the park.
Wait a minute. Wait a minute.
Hold down. Hold down.
It's me, Melanie says, just reporting that Hank Brennan is on the Turtle Boy case Zoom. Oh, he's
Wow.
watching some shit, huh? Let me see. I'll check it out. I'll go live, see if I can see him.
See what you can see, girl. All right, hold on. I'll be back.
I mean, we can't see it. Like if he's on there, it's not showing on like the thing. Oh, I got a new witness up. Let's see who this woman is. Lauren Cologne. So yeah, I can't see him if he's on there. So she's taking pictures in the courtroom. Oh my Lord. I think she said I'm an exotic dancer. I mean, I don't know. She said I'm a something dancer. Oh, project manager. Sorry. Not an exotic dancer. It's a project manager. She did not look like an exotic dancer. I was like, oh, she's a very, business looking dancer. All right, strike it from the record. Somebody strike it from the record. My Lord. Project manager. All right, I'm putting this up so you guys can hear because it's what it sounded like. Let's see. I'm just going to play it. I'm just gonna put this thing back. And
Good afternoon. State your name and spell your last name, please.
OL,
And where do you live, just generally?
in the Norfolk County.
What do you do for a living?
I am a project manager at a large company. I work at a
well, now that you've heard me say it's project manager, I think you can't even hear what sounded like the answer. But yes, she is a project manager. She's very appropriately business-like dressed. And there's nothing wrong with being an exotic dancer at all. I just don't think if you're not one that you want to be portrayed as one. But I heard dancer where manager was, and then my mind just was trying to put it all together. Whatever. Say goodbye to the screen. Ay, ay, ay. So like I don't know if he wants to portal. Yeah, that's what I thought at first. It was private dancer. I was like, wait, what? That's Teresa. So at least you guys don't think I'm just crazy. But yes, she is a project manager at a very large company. And that's all. All right. So I don't know what happened to Bob. And I'm assuming that he wants to get this portal. Oh,
All right,
here it is.
dude, kill 5 minutes. Like
Kill
seriously.
5 minutes. Okay. I will kill 5 minutes.
Do you want to handle trying to figure out this thumbnail thing and setting up the thing?
No, hell no.
Because I'll kill 5 minutes easy, standing on my head.
Standing on his head.
Standing on my motherfucking
I
head.
mean,
All right, I'll be right back. Right back.
okay. Oh boy. I don't know, people. I don't know. It's been one hell of a morning. Yes, behave, Bob. Standing on his head. Oh yeah. Speaking of behaving, if you were one of the first like 10 people into the live this morning, I don't know what Bob was speaking of. I did not distract Bob in any way, shape, or form. Those were lies. Absolute lies. I don't even know what he was getting at. Bob can do a lot of push-ups. I mean, he does like I think 250 a day or something. I don't know, but it's a lot. He does them every night. But I don't think he does all of them at the same time. So that's what I'm not sure about. But he does a hell of a lot of them. But yeah. Oh, right, Lori. He said I was distracting him with my womanly ways. That's, not what your mind all thinks. I mean,
That's exactly what
Stop. Stop. You're not. Go do what you're doing.
Okay.
Jesus. Wow. This guy, he's something. I mean, exactly. TMI. TMI. Lori says, I figured you were twerking. My vape is honeydew apple. It is not. Bob told me the other day, he's like, you really are going to have to stop vaping. Everybody thinks you're smoking pot. I mean, who smoke? I mean, I guess there are people that do it and can do it, but just smoking pot all day, like every 2 minutes, seems like a lot. For me, I'd be just on the floor. So, and Amy's, she's vaping right now too. I mean, a good melon is good. I definitely like a melon because it's not as sweet. But it has like a little sweetness, so it's nice. I don't know why people get so offended. I'm vaping in my own house. What's the difference? Nicotine vape. So, I shouldn't make any achy noises. I don't know. What do you guys think? I mean, if you're keeping your body close to yourself, is it really a risk if you're going on like rides? I don't know. I don't know. I feel like you can get away with it. I don't know though. Probably shouldn't go. I'll do something stupid. And we are planning a trip in a couple days. I feel like this is like a pre-trip for Scarlett because we're doing this for her birthday. With like a whole group of kids. So I think she's like, all right, I want to get back out there. I want to figure out what's the best ones, what we're gonna do. Gonna have like a little preview. We don't go enough to Great America, and we have a like membership or whatever. It's a complete waste of money. Complete waste of money. But yeah, I mean, typically I would go and say, screw it, I'm fine. But I couldn't even like carry a cup in my hand over the weekend. So it's pretty bad. They ordered me an MRI yesterday, but I can't get in before my appointment for the orthopedic. So I don't know. When we get off, I'm going to try calling, seeing if I can get in, and then calling the orthopedic to see, do you have an MRI machine right in the building? So if I don't get it before I come, you can still do it. Because Mary Holt's like, don't go. Don't go. But, right, but who would do the baby rides with me? Nobody, not even Scarlett would do baby rides. The baby rides. But Ernie says, Allie, don't go on rides. The bopping around will not be good for it. Oh, no, I just have to come to terms with it. Oy. And then Amy says it's very unlikely they have an MRI machine in the orthoped's office. So that's what I'm going to be doing when we hang up. I'm going to be calling and saying, no, y'all got to get me in before my appointment. And then, I don't know, maybe maybe my doctor will make it a stat thing. I don't know if he will, though. Oh, yes. PV and Shelly. That's what I'm going to ask Bob. I'm going to say, Bob, I want to go on the baby rides. Will you go on them with me? I mean, the swing, it's fun. It's not a baby ride. We could, but there's no banging. But I have an old rotator cuff injury. And then Bob and I sort of both damaged our shoulders. And doing CrossFit for a really long time, but it was a while ago. And then they just eventually started to feel somewhat better, but so romantic. I don't know, we'll see. Gotta think about what other baby rides there are other than the swings. This is turning into a lot more than 5 minutes. Yeah. So Mary had a torn rotator cuff. It just got worse. I had surgery. I feel like that's, with the amount of pain that I'm having, I feel like it's actually started traveling down my arm into my forearm, which seems insane. That's new. But so, all right. So let's see. How many of you who's got some ideas for hours and times for Verdict Watch? Like, what time of the day should we do Verdict Watch? It's no one wants to sit around all day, doing a Verdict Watch. So we need a time frame. Let's do Verdict Watch, every day from blah, blah to blah, blah. And obviously, if they have any questions, jury questions or something that comes up, we'll actually have to hop on and go live. But I honestly think, I was telling Bob this morning, that I think it's got to be not guilty. And we are having some thoughts about some verdict watch guests. Like Bob and I talked about it. I got to reach out to we both have to reach out to some of our fellow content providers, see what we can do, see what we can come up with, but try and do something fun. So we've got some stuff that I don't want to just start throwing out because I haven't talked to anybody yet. But Keith, that's one of the names on the list of who I'm supposed to reach out to. I got people to reach out to. Bob's got people to reach out to. I'm gonna try to come up with some stuff. But I mean, for all we know, they come back quick as hell. To me, it's like a no-brainer, not guilty. It's just, I just don't get it. I don't get it. A lot of you guys are saying they think they'll be done Friday, end of day. You know. Jen says, have a glass of wine. Does that help with pain? My pain does feel, I mean, it's still there, obviously, but it does feel a little better today. I took the double dose 2 prednisones yesterday, shortly after the live ended. And then I took 2 first thing this morning. And it is starting to feel better. Shaboogs thinks 4 hours top for the jury. I mean, all the experts said no collision, you know. Could be a not guilty party weekend. So Shaboog says that she was at 6 hours until the x-rays came down. You know, so. You know, I think it's fair to not know what stricken means in a court of law, you know, and that does, you know, so this is Mary's comment. Like if a juror didn't know the definition of stricken, the jurors need to be explained the meaning of reasonable doubt. Yeah, for sure. And I think it just goes to show that we say things and we just assume the jurors know what the hell we're talking about. We as lawyers and judges, you know, but stricken might not mean the exact same thing in a court of law. It probably isn't as, you know, obvious as you know, like the system thinks it is. That jurors just understand all of that. And I think at some point, you know, when they get like those massive instructions early on, people are zoning out. You know, like because I think in the initial instructions, there probably is an instruction that's like, if I say something is stricken, you ignore it. It's gone from the record, you know, whatever the case may be. But it's better that people ask, you know, that they ask the question. So KKB said, I think the explanation of stricken was just to that witness. It was the ARCA accident recon test, maybe confused if that was stricken altogether or just the witness, which was La Posada. Yeah, there's really no telling, you know. Yeah, Tracy, I mean, I should just do that. I think I will. And we talked about earlier, you know, why they might have dropped the missing witness instruction because they get to make the argument and there's not all that limiting language that comes with the instruction that the jurors could go back and be like, well, but it said don't think about it unless this. So let's not talk about it at all. Let's not think about it at all. You know, um, it there's a lot of things that the judge should realize she needs to clarify that didn't seem that she was so inclined to do, you know, when she's talking about it in the jury conference. So, you know, she keeps saying she's going to give more robust instructions, and I'll give what I gave last time, and we'll do this. But I mean, like, why are you fighting the lawyers for 15 minutes? It's another half hour total. You know, it's like I mean, really, it's another hour from the 2 hours. If you take it as one for them, one for the prosecution, you know, it's another hour altogether. Right now, it's another half hour. She's already given 15 minutes, but just like, come the fuck on. It's kind of crazy. Court is long over for the day in Karen Reed. We started to watch a little bit of Aiden's trial. It's not the big trial. This was a trial for violating a court order, the restraining order. But so Kaylee says, Allie, last time I don't think Lally did rebuttal closing argument. Is that allowed in Massachusetts? And he just didn't do it. I'd be surprised if he didn't, if he put everything before it. There's always, the prosecution gets to go last, always and forever. So if he didn't do it, that's just the way his time worked or the way he chose it. I thought he did do it, and then he ran out of time and didn't get to say his like last sentence, but I might be thinking of something different. You know, all these cases kind of blend together, but they definitely do have the do get rebuttal closing argument, and they almost always, I mean, I've never seen them not take it. But yeah. If they come back really quick, like, so typically the defense is like, all right, the longer it takes for them to come back, the jury, the more likely it is they're starting to talk about, they're starting to get towards like a guilty thing. But in this case, I feel like if they come back really quickly, that's a not guilty. That's a not guilty for sure. I just don't, this is not the type of case that they can come back really quickly with a guilty verdict, because there's no fucking chance in hell that 12 people can agree that she's guilty on something that quickly. Not with this case, not with these facts, not with what they heard. There's going to be holdouts and this, that, and the other. So if somehow they came back quick, I think that's NG, in my opinion. So we'll just have to see. A lot of you guys are agreeing. But I mean, it seems so obviously not guilty, you know, but I feel like it seemed that way last time too. I don't know. I don't know. And we never really heard the judge is like, I don't think I'm going to give your proposed instruction, Mr. Yannetti, for 2, but I really, really think it needs to say, like guilty and not guilty, for all the options, not just because then people get confused. Like they've got to sign something, and the only thing to sign that says guilty. So I do think the defense did get more in this trial. There was more helpful stuff. The way it was presented was more helpful. The order it was presented in seemed more helpful. So yeah. I wonder if Bob's just still back there listening with a blank screen. So I'm not sure what the verdict plan watch is for tomorrow. We'll come on early for, we'll start the live early because the lawyers are supposed to be there 8:30 Eastern time. And so we'll probably start at 8:45 because that's what time she wants the jury there. And then we'll see if they start a little early. We'll listen to the jury instructions, watch when they leave. And then I don't know. Bob and I are gonna have to talk about it. We're gonna figure this thing out. But we're gonna start tomorrow at 8:45, at least 8:45 Eastern time. And then kind of let the day develop from there. I don't know. Do we know if oh. I hope Bob didn't try to sneak out.
No. Oh my God.
There he
You're
is.
killing me. You can't kill 10 minutes of time.
I did.
Dude, it was
Are
like
we done?
I'm sitting here listening to you. Like I kill hours.
I know you're great at that.
It's not. Come on, man. I was trying to get shit
All right,
done.
it's ready now, right?
It is.
Okay.
It is ready. So, all right. Everybody on that thumbnail, because I don't know where Mandy is. So I had to use an old thumbnail. It's tonight. It's not whatever the date is on there. It's tonight. Tracy's going to try to work on it, or I'm going to try to get Cameron to work on it. But it's tonight, 7 p.m. Central, 8 p.m. Eastern. Mark Betterow is joining us. It'll be our conversations with Mark are always awesome. I always really, really enjoy them. So spread the word, be here, set your notifications. I will figure out things to do during Verdict Watch. I'm not going to we're probably going to stream most of the day, whether it's watching old testimony. I'm definitely going to watch the openings. I still want to watch the openings. I absolutely want to watch the opening statements because I want to see.
Betterow is tonight, 7:00 Central Time.
Betterow is tonight. Set your notifications. Go to your notifications. Everybody, you should have your notifications set for us anyway. You just hit that little bell.
All right, I'm coming to get ready. I'm coming with you guys. I'll just watch. And
all right, hurry up, get changed because we're about to dip. So yeah, tonight, again, 7 p.m. Central, 8 Eastern, Mark Betterow, and we're going to hang. We're going to hang like we always hang. We are going to hang, and it's going to be great. All right, you guys. So, and look, in our community page, if you guys have anything that you'd like to see when we have downtime during jury, because look, I mean, we can't just assume that this thing's going to be 4 hours. You never know what a jury's going to do. We have to we have to hope for the best, prepare for the worst, which means I've got to try to figure out content to try to fill, because as much as I can yammer, and you guys know I can yammer, I am a talker. Doing that for 6 hours straight without some kind of buffer will be extremely difficult for me, even for me. So if you guys have some concepts of some things that you'd like to watch while we're killing time, while I'm keeping an eye on the clock, watching the courtroom, see if we're getting a verdict, you know, we'll like, I'll happily take any suggestions from any of y'all in the fam. Like, so, you know, I want your voices to be heard, kids. All right. We love you guys so, so much. Thank you all for your generosity once again today. I'm assuming Allie got through all the supers. I don't know that I got any Venmos or Cash Apps or anything like that. It doesn't look like it. So I think we're good there. I'll just check the Cash App thing. We did. We got one. So Barb sent a $5 Cash App. Thank you very much. I got it. Appreciate that so much. She's a newly converted, so welcome. we were hearing about that yesterday in chat. One of our ride or die fam got their mom hooked on the show, so that's always awesome. That is exciting. All right, I am off to go do something fun with my kid, so I'm excited about that. Little Great America. Allie's gonna come. You guys, don't let her get on a ride. She doesn't listen to me. You know, she's like, you know, she does what she's gonna do, which obviously is her, you know, obviously it's her prerogative, but I don't want her to be in pain. So like try to use all your thoughts to not have Allie, because she'll get on a coaster. She won't be able to help herself. So you know, think all your thoughts. Stay off the coasters. Stay off the coasters. All right, you guys, we will see you tomorrow. Big day, opening statements. But before that happens, make sure you're here tonight at 7 p.m. Central, 8 p.m. Eastern for the return of Mark Bedrow. Part three, third time he's come to hang with us. They're always great combos. And Mark, for whatever reason, Mark feels like he can let his hair down a bit more with us than he does on other shows that I've seen. So, which we like you to be able to come in and just be yourself. You know, if you use potty language, fucking swear. You know, we're not judging. I mean, Allie and I, Allie especially, she's got a really potty mouth. You know, it's like I do too, but not as bad as her. She's the queen. All right, y'all, we love you. Have a great day. We'll see you tonight. Get some food in your bellies, maybe take a nap, spend some time with your pets, play with your kids, whatever you're going to do. Whatever you're going to do. We'll see you tonight. All right, y'all. Love you. Bye.